The court has no authority to decree that an erroneous precedent is permanently exempt from evaluation under traditional stare decisis principles. Adherence to precedent is the norm, but not an inexorable command. If the rule were otherwise, erroneous decisions like Plessy and Lochner would still be the law. Close quote. Professor, isn't that inarguably true? Mustn't it be the case that all prior decisions of the court are subject to reevaluation?
Well, it is certainly the case that we have in the legacy of this court, Dred Scott, Plessy v. Ferguson, they fell after Brown v. Board of Education. So the ability to be able to review is important. That's the ability to be able to review. It's another thing when the Supreme Court then strips away a fundamental protection that has been made, particularly given that the justices who may be involved in this leaked draft opinion suggested that they actually respected the precedent and stare decisis associated with Roe, and we were not talking about Plessy v. Ferguson or Dred Scott when they said that they respected that stare decisis.
Well, if those are examples, so Roe and Casey would be equally susceptible to reevaluation as Plessy. Would you agree?
Well, and in fact, they certainly could be and be further expanded, and they have been. So one of the things we haven't talked about is that there is Whole Women's Health v. Hellerstedt, and even just a couple years ago, June Medical v. Rousseau, which this Supreme Court used to further uphold the principles of Roe v. Wade and also Planned Parenthood v. Casey.
I yield back.